It is. They have waived the oral argument. I guess I was pondering as I was coming here whether I want to keep 2 minutes of rebuttal, just in case I say something against myself and I have a need to correct myself.
You never know.
You never know. Your Honor, this is a pretty simple case with a unique issue. Obviously, let's start over. Good morning, Your Honors. My name is Jeff James. I have been appointed to represent Stephen Carrion in the appeal in this case. He appeals his conviction under the dogfighting statute of Ohio Revised Code, Section 959.16. He was convicted under A5. It is a felony in the fourth degree. He was placed on community control with a reserved sentence of 10 months. The issue presented here is somewhat unique. We don't often have an opportunity to address statutory construction, but that is the issue that brings us here to the court today. The issue of the statutory construction of Ohio Revised Code 959.16 was not lost upon trial counsel in this case. Trial counsel made sure that the record was properly preserved on the fact that they were challenging that statute as it is written and requesting additional jury instructions, one of them being that the mere presence at a dogfight in and of itself cannot be, under that statute, a basis to find him guilty, and that was one of the things that they had asked that the court give that jury instruction, which the court refused to do. There was also kind of related to that was that there was also the instruction asking that you can not make inferences upon inferences improperly. What brings us here is that Ohio Revised Code 959.16 A, 5, and 6, and he was charged under 5, but 6 is kind of relevant with regard to the issue of statutory construction. It states that no person shall knowingly do any of the following: pay money or give anything else of value in exchange for admission, or be present at a dogfight. And then 6, witness a dogfight if it is presented as a public spectacle. The issue, very simple, is what do we do with that dangling phrase, or be present at a dogfight? The idea behind it is, or the argument, of course, being presented here is that it's superfluous. Why do you have that in there? Why would you even need, or the legislature need to put in there, pay money or give anything else of value, if the mere presence at a dogfight was in and of itself a crime? What does it matter whether you pay or give anything of value if the mere presence at a dogfight is the criminal offense? Yet this legislature did put that in there. Secondly, under 6, subparagraph 6, or really sub-sentence 6, witness a dogfight if it's presented as a public spectacle. I'm not sure whether we define what a public spectacle is, obviously in some way open to the public. But here again, they sought to specifically put in there that the crime is being present. It is simply being a witness of the dogfight when it is a public, presented publicly. And there you do have a separate crime, all right, to be present, but only when it is presented as a public spectacle, or open to the general public. And I don't have a lot more to say. If we look at rules of statutory construction, which I have set forth in my brief, how this court must reconcile the differences there and understand what exactly is the legislature trying to achieve in this goal of trying to somehow restrict and outlaw dogfighting and participation in the dogfighting. Now, if we want to get into the facts of the case, what we know about this case is that this was really a kind of a backyard area where there was a gathering of people to watch the NBA game. Inside the garage, which you had to pay additional funds for to get into the garage, there was dogfighting going on. There was no evidence in this case that Steve Carrion was ever in the garage, or that he had given anything in exchange to be in the garage and to observe or participate in or to be present at this dogfight. Now that, of course, goes to the second claim, and that is just that the conviction was against the manifest way of the evidence in this case. But we still have to get back to the main point, is that, and I was hoping that there would be questions. But the fact is, I don't have any. I mean, it's there in the brief. It's pretty clear. And I don't mean to challenge this court, but if this court somehow says, I'm going to try to reconcile those two, I can only tell you that is wrong.
Well, one reason why there's probably no questions is
aware that you had written that a few months ago. And I did want to, because I did set this for oral argument because I think it was a unique issue to raise. And I did, of course, read the Taylor case, and I understand where you came, or your position with regard to the Taylor case. I do believe that the reasoning behind it was an error, because I don't think there's any way that you could properly reconcile the mere presence, all right, with the language that precedes that, and that is that you have to pay or give something of value for it. How do you reconcile those two? Why would the legislature put the other one, put that in there?
Well, I guess, just out of curiosity, so if you're looking at 5, it says pay money or give anything else of value in exchange for admission to. So if you're paying money to, say hypothetically you don't go, you bought a ticket, but you didn't go. But you bought a ticket to go, you just didn't go.
Right.
But there's, and then this is a good case because not only have we talked about dog fights exhaustively over 47 years.
Sure you have.
We have settled this law for years now. But because this was in a compound and the fence was 6 to 8 feet high and it was pretty much self-contained, it wasn't a public spectacle, there was a fence all around it. Right?
Yeah, this was not a public spectacle.
Right, so we're only looking at 5. And I guess, so there's people that are milling about outside the garage. The fight's going on ostensibly in the garage, right?
Correct.
And then there's people all milling around outside. We don't know who paid money to go in the garage, assuming that that's what happened, don't know. But there were people that were within the confines of that yard who were present.
Had a dog fight? In what way?
We're in a confined area. It's not a public spectacle. It's in a confined area. I mean, this is a good case because the facts are so. It's a law school. It's a bar exam.
It's a bar exam question. It probably is. But I guess the point is that we have an enclosed area where the dog fight is going on. The fact that people were present in the compound does not make them in any way participating in, observing, or being present at the dog fight. They may not even know.
The complicating factor of the 2 people that are standing there with the 2 dogs on the leashes, not in the garage, and they're egging the dogs on right there, not in the garage, outside in the general area where,
So,
it's a good set of facts.
so the idea was at that point, because of the activity that you see outside the garage, you must have known what was going on inside the garage.
Well, I guess arguably you could say you're present at a dog fight.
Yes, and that's the whole issue. You're saying that the mere presence, that this means that the construction of this statute is such that the mere presence at a dog fight is in and of itself the criminal act?
So that's how this court has read it to be in Taylor.
Then why, I guess the question that comes into play.
If you're buying a ticket to go and you don't show up, but you got a ticket, your name is on the list.
That would be
you bought
criminal.
a ticket to go, and you didn't go because you paid money in exchange for admission to, even though you didn't go. You bought a ticket to go.
So you would be criminal under the statute because you paid money or gave something of value even though you didn't go?
Under A5, everything up until the word or.
Up until the word or. But I guess the question that comes into play is that, so what you're saying is that in a private, the mere presence at a private dog fight is criminal, all right? And why would you have then, the statute have to have the additional language that the mere presence at the public spectacle is criminal? Why would you have to, how do you reconcile the fact that this legislature felt that there was a need to differentiate between a dog fight that is public and a dog fight that is not public? Because the mere presence under A5 would put you in a dog fight, whether it's public or not public, and therefore that in and of itself would be criminal. So why do we even need to have 6? How do you reconcile 6 against 5 under those circumstances? That's why 6 is kind of important, because the legislator felt the need to put out there that here the mere presence is criminal.
Mr. James,
Mm-hmm.
would the word to, T-O, placed after the or in section 5, cure the argument that you're alleging?
Oh, yeah, or to be present? Yeah, that might reconcile it. Right.
Well, that would mean that.
But you're still back in the same situation. I'm saying it could, at least we would have some additional input from the legislature as what their intent was, but you're still back in the same situation. If you're going to say that one section there, all right, outlaws the presence at any dogfight, presence at any dogfight, why do I have to differentiate public versus private? I don't need to, because any presence would be a violation. But this legislator said, no, here we think that it's important that if it's a public spectacle, the mere presence is criminal.
Well, it's a witness.
Well, okay. It sounds like presence to me, but we can all play with that.
Well, I guess here's a question, if it's Skype or FaceTime, you're not actually there, but you're witnessing the dogfight.
So you think the legislature meant?
No.
I know, right.
I don't know this
Just-
law, specifically what the law
I,
is.
I surely hope that we're not going to go down the line of kind of like with child pornography, of saying that somehow if there's online dogfighting and you have somehow observed, a YouTube of an online dogfight, that you now have committed an F4 felony in the state of Ohio. I hope that that's not the goal that they were trying to achieve, because that would be a harsh goal. So that's the issue. How do you reconcile the two? I mean, if mere presence is what is required, why do you even need 6? But they put 6 in there. So I have difficulty with the language of this statute. And what's important, and I'll finish with this, because I really don't have any more to say. I know that you decided Taylor. I would like this court to revisit it, because I think that there's nothing more important than statutory construction. We rely upon laws to tell us what's right and what's wrong, what we can and can't do. And when they're not clear, we need someone to go back to the legislature and say, you know what, you didn't do it very well. And we know that you didn't, that you're not trained like we are. You're not attorneys. You may not be the people that are best apt to do this, but you know what? You have a job and you have a lot of attorneys and a lot of people on your staff. And if you can't get it right, we're going to tell you that you didn't get it right. Why? So that you can correct it. Because if we just let things go that need to be corrected, then where are we going? Where do we end up? Someone needs to tell the legislature, this is not clear language, it's pretty poorly written, please do something about that. We're not going to enforce it the way you've done it, and we're asking you to change it at this point. And that's an important task. And you know what? That's your task. Because it is the judiciary that monitors the legislature and the legislature behavior. Because if we don't have the judiciary doing it, then who is doing it? No one else. With that little bit of editorial, I'll finish if there's no further questions. Thank you. It's always fun. I didn't even need my 2 minutes of rebuttal.